My name's Charlotte Burton. I'm the marketing manager for CCLS. I've been running discovery webinars kind of throughout the year. So you might have met me or seen me already. And we've also been running a series of taster lectures throughout June, all on different topics. So we've so far had tax law, we've had intellectual property law, today we've got banking and finance law, and still a couple more to come. So just to give you a flavour of the teaching that we have here at CCLS, and also as this may be your specialist subject that you're particularly interested in, for you to meet one of our professors as well. So during the session, we will be going through a taster lecture, which Rodrigo will be very well versed in taking you through that, as he's been with us for quite a long time. So he'll take you through that. We'll also have a Q&A at the end where you can ask some questions. If you have any to Rodrigo or myself, neither of us work in the admissions function. So I would suggest if you've got questions related to admissions, I will put the email address in the chat here for you. However, we might not be the best people to ask. However, if there's anything particularly related to banking or finance law, Rodrigo can help with that. And I can generally help with student-based questions, just from being in lots of webinars so far. So learning lots along the way. So it's 5:25 to. So Rodrigo, I'll kind of hand over to you. I'm sure people will still keep joining as we go along. I'm just conscious of your time, as I know you're having a very busy day. So I will pass over to you. Just a reminder for everyone, if you want to use the chat or the Q&A function, please do throughout the session, and we'll come to them at the end. Rodrigo, over to you.
Thank you, Charlotte. Welcome, everyone. I don't know why the setting, I cannot see you. I cannot see those are the participants or where you are from. But I would like to extend a very warm welcome to everyone. I'm a professor in banking and finance law at Queen Mary University of London, where I've been for a long time now. I also am a regular visiting professor in other universities, in China, in France, in Italy, in Spain, in Argentina, in Colombia. So I travel the world. I lecture here and there. Actually, tonight I'm giving a guest lecture in Latin America, starting at 9:30 p.m. UK time. And today I'm addressing you from Paris. I came to Paris because we have a campus here in Paris where we teach some of our courses. It's a program that is run completely, entirely in Paris. And last night I was hosting an event, a conference, where we have people from UNECA, the United Nations Economic Commission for Africa, and also the Secretary General of the Paris Club, the partner of Wilkie Farr, an American law firm, the managing director of Global Sovereign Advisory, which is a financial advisor in the context of sovereign debt, and people from the African Legal Support Facility, people from the OECD. The event was co-hosted between Queen Mary and the OECD, who you might know has its headquarters here in Paris. So this is just to give you a little bit of a flavor of who we are, what we do. And the idea today is in the context of banking and finance, if you are looking forward to do that specialization or some of the other joint programs that are closely linked to banking and finance, which is the LLM in law and economics or the MSc in law and finance. I'm the director I'm the co-head of banking and finance, and I'm also the director of the MSc law and finance and the LLM law and economics. So that's why in this session, we try to kind of bring together all these three programs. And they asked me to do a little bit of a teaser, a taster of what the lectures will look like. The problem is that to do that in 15, 20 minutes, sometimes it's a little bit challenging. So what I decided to do today is to do a mini lecture where we have an overview of an M&A transaction. So basically, how do you structure, and M&A transaction, from beginning to end, looking at the different key milestones that you will reach as you go along. I will strongly encourage you to ask questions if you do have questions. I assume since we cannot see you, this should come through the chat box or the Q&A function that you can find both of them at the bottom of your screen. So what I'm going to do now is I'm going to share my screen, and you should be looking at my slides now. Charlotte will nod in agreement. And basically what you have there on the back of the image, that's the Bank of England. That's the central bank in the UK. And that's closely linked to what we do here in banking and finance, where we have courses on central banking, monetary policy, although of course all of this from a legal perspective. And our courses in banking and finance, you can broadly group them as a regulatory, that they look after the regulation of both banking transactions, the banks themselves, the markets, or transactional, that they look more at how the transactions are structured. Within that, it's not a divide, but basically for you, you can select if you want to go more into regulation, where you study the law, the rules, etc., or more on the transaction, which is how to get the deal done. Today's presentation will be a little bit on the second one, which is how to get the deal done. So what I'm showing here, what I'm presenting here is what I call, this is something that we looked into. This is touched very briefly, some of these aspects in a module on corporate finance law, but mostly and in more detail in a module on mergers and acquisitions. What you see here is what we refer as the acquisition phases. These are the 6 phases that you come in an M&A transaction from beginning to end. And sometimes it's important to have this overarching look, because when you work in a law firm, you are mostly entrusted with a specific aspect of the transaction. Like, for example, perform the due diligence, negotiate the share purchase agreement or a specific aspect of the share purchase agreement, or probably negotiate one of those ancillary agreements, which are the accessory agreements that go jointly with the SPA, either as a standalone contract or as an annex to the share purchase agreement. I will use interchangeably share purchase agreement and SPA, the acronym or the short for the share purchase agreement. When you are going to start in any of these transactions, the first thing that you need to do is you need to conduct an initial analysis, assess the feasibility of the transaction. You would explore issues such as pricing, whether a potential target company is within what you consider is your price range. And then we're going to start looking into the structure. The structure is something that you should be looking at from the outset, because the first question, the million-dollar question in any of these transactions is whether you're going to buy the shares or the assets. And there's a big distinction, because when you buy assets, you get to cherry pick what you want, and what you get is as is. So it's like you go to a supermarket, you want to buy fruits, you might not know which fruit you want to buy, and then you select that you're going to buy bananas and apples. And then what you do is you cherry pick which banana and which apples you want to buy. That's the idea. Then if the banana or the apple doesn't taste as you expected, or it's not of the quality you expected, that is your loss, because you get it as it is, you know what you're getting, you decide to buy it as it is or not. However, when you buy shares, the big distinction with shares is that when you buy shares, you get all that you are entitled with when you have the ownership of the shares. Charlotte, I don't know if participants can participate talking to us, but if I will pose a question, and if you cannot, at least on the chat, and there's a comment on the chat. Yes, you put a feel free to ask questions. Yes, when you buy shares, and the question is, what are you entitled by owning shares? I will pause there for a few seconds to see if anybody wants to contribute on the chat. Nobody, everybody's shy. Well, there's something that you will get in the Anglo-Saxon system is that basically we don't like to hear the monotonous tone of our voice. We like to interact with students, not as a way of assessing you, but basically as a way of discussing, making sure that everyone is following, but also because we see this as a two-way experience. It's not just us sharing with you, but it's also you sharing with us. You come from an array of multiple jurisdictions, and we always find value in what you contribute, what you share, based on the experience from your own jurisdictions. When you buy shares, what you are entitled to are rights and obligations. Everybody jumps and always tells me, yeah, the right to vote. But the right to vote is only one of many rights that you get. But most importantly, as a lawyer, what you need to assess is the issue of liabilities. When you buy the shares, not only you get the right, but you also get the liabilities. And that has to do with the structure. And basically that the first milestone is whether you're going for the shares or the assets. You might still do not fully know this because you still need to do a due diligence, but this already will tell you in which direction the transaction will go. On structure, we will also discuss some issues as to what is most convenient from a tax perspective, whether you're going to buy with an operating company, whether you're going to create a special purpose vehicle to acquire the company, and whether that special purpose vehicle should be incorporated in a advantageous tax jurisdiction. Most likely in this pre-due diligence stage, you will also enter into an NDA or a non-disclosure agreement with the shareholders of the target, the sellers, and this will conclude pretty much the pre-due diligence phase, which is the preliminary stage. Then you move into the due diligence phase. The due diligence phase, as its name indicates, is where you perform the due diligence. For those of you that are not familiar with due diligence is an audit of the company. I prefer to put it in slightly more clearer terms. A due diligence is like performing an X-ray of the company. You want to get to the bones of the company. You want to see what is behind the face. In this due diligence, and as most of us, but not necessarily all of us, because sometimes we come in the classes, we are joined by economists or accountants, but the one that we care the most is about the legal due diligence, where we look at the due diligence is essential. It's the cornerstone of any transaction, because the due diligence will allow us to first determine whether we want to go ahead with the transaction or not. If we decide to go ahead, what will be the price? Whether we also has specific ancillary agreements, which is, for example, like an escrow agreement. That means that you put some money apart, held by a third party, that third party will administer that money, and if a liability materializes, that money will go to the buyer. If no material liability materializes, that money, which is seller's money, will be handed to the seller. So this is the due diligence which allow us to kind of pinpoint precise a little bit more how the transaction will shape. Then you move into the documentation phase. Documentation is when you, as its name indicate, document the transaction. The issue that the main contract is the one that we have here, which is basically the SPA or the APA, which is a share purchase agreement or the asset purchase agreement. And then the one that was just mentioned, for example, whether you're going to have an escrow, right? You allocate part of the purchase price to a special, between inverted commas, kind of sub-account that will be held by a third party. That is part of the purchase price. But if a liability materializes, that rather than going to the seller, goes to the buyer. Cover for the liability goes back to the seller because technically it's part of the purchase price. Therefore, it is seller's money. In this documentation phase, then you can also come across some other contracts, like a shareholders agreement. If you sell a percentage of the shares and you don't buy the totality, a call or a put option, that means the right to buy more shares in the future, or if things do not work as expected, you have a put that basically you bought 70% of the shares, but you have the right to ask the seller to buy back those shares from you in the future. That is a put. And then some other agreements like the KER, which is Key Employee Retention Agreements, like a non-compete agreement if you fear that the seller might set up a new business doing pretty much the same that they were doing before, then you might want to make sure that that he cannot compete with you. And you do this for the purpose of being protected from losing a market share. Then, for example, consulting agreements, if you want the seller to continue being part of the business, the seller, you might enter into a consulting agreement. So in that way, what you do is you allocate part of the purchase price to a consulting agreement, and therefore, rather than spending more money, I mean, money for buying the company and extra money for consulting, if you know this clearly from the outset, you can put part of the purchase price that is going to be disclosed upon consulting services. Then what we have is the pre-closing, which is when you sign the contract, and then the closing. These are concepts which are very important, and I would like to bring your attention to this in the sense that pre-closing is once you have finished negotiating the contracts. Usually this can take, it depends on each transaction, but I would say an average of 2 weeks to 4 weeks. And you negotiate the contracts, you negotiate the annexes to the contracts or the ancillary documents. You have your set of documents, and then you sign this. In any share purchase agreement, most likely you will come across almost invariably in every transaction that there is a set of conditions precedent. Conditions precedents, as its names indicate, it does pretty much what it says on the label. These are conditions that are precedent to the transaction being completed. So what you have, or what you achieve with these conditions precedents, is that the seller has to meet certain conditions before the actual acquisition takes place. But Rodrigo, you just told us a few minutes ago that you signed the contract. Yes, but that contract is conditional on these conditions precedents being fulfilled. Typical examples are putting the corporate records in order, for example, reducing the workforce, for example, getting authorizations from the central bank, because certain jurisdictions there are restrictions on the free transferability of monies, or for example, it can be that you need to get approval by the competition authorities before you can proceed with the transaction. That's why we have this pre-closing phase, and then we have an actual closing. Closing is the day that all these conditions have been fulfilled. That is when the transaction actually takes place. That is the day that monies are paid and shares are transferred. So basically on the pre-closing, which is signing, you just have a binding contract which will not produce effect until you fulfill the condition present. Once these conditions are fulfilled, that's when you have the closing, and this conditional gets replaced by the definitive contract. However, one important aspect that I would like to bring to your attention, and that's what I have there at the bottom, is that once you finish the due diligence, once you finish the due diligence, then what you have the due diligence here, you finish the due diligence, and then that's when you did the X-ray of the company. And then you have 2 to 4 weeks to negotiate the contract. Hopefully this has never happened to any one of you, but basically one day you were walking on the street and then you sprain your ankle and then you break a bone, right? So basically you took an X-ray in the morning and in the afternoon you have a broken bone. Is the X-ray accurate? The X-ray was accurate at the time that X-ray has been taken. And that's what I'm trying to highlight here. By the time that you finish your due diligence and you negotiate and sign the contract, here you have a period of time that has a degree of uncertainty. During that period of time of 2 to 4 weeks, anything can happen. In the morning, you were fine. You did an X-ray, no broken bones. In the afternoon, you trip on the street, you have an injury, and then you end up with a broken bone. That will not appear in the X-ray that you took in the morning, which is the due diligence. So you have a period there of uncertainty, 2 to 4 weeks. However, then you sign based on the due diligence that you have conducted 2 or 4 weeks before, and then you have a month, 2 or 3 until the conditions are fulfilled, and then until you reach closing. And that's where you have this XT2, that's X, which is in our case 2 or 3 months. So 2 or 3 months time. So basically you add XT2, 2 or 3 months, let's say 3 months, that's 90 days. Plus between due diligence and signing, we have 30 more days. So bottom line, from the day that you finish your due diligence until you get to the closing, what happens here is that you end up having, between due diligence and closing, you can end up having 4 months. And what has happened in those 4 months? You have a company that had been run by the seller, but you are buying that company. So in these 4 months, absolutely anything could have happened with the company. Just to give you an idea, Lehman Brothers was rated AAA 1 week before it collapsed. Imagine if that happened in 1 week, what could happen in 4 months? So the question here is, how can we protect ourselves from that adversity? How do we hedge that risk? And usually what you have there is, in these SPAs or share purchase agreements, you will include a standard clause, which is called the MAC clause or the MI clause, which is material adverse change or material adverse event clause. And the whole idea is that that clause will allow you to have an exit strategy if something has changed dramatically or substantially from when you have finished the due diligence. And then when you sign, at signing, the lender will confirm, sorry, the seller will confirm that none of the information obtained in the due diligence has changed. And then at closing, he will do the same. However, if a material adverse change or a material adverse event has taken place, technically, you will have the right to walk away. For example, picture yourself in January 2019, you finish your due diligence, you're going to buy a company, and then, oops, COVID kicks in. That would have been material, that would have been adverse, particularly if you were buying a hotel, for example, or an airline company. And that is a way of being protected in this type of transactions, particularly because you as a buyer, you are doing this relying on the information that the seller provides you. The problem that you have is that in any of these transactions, there are some elements that are private in nature, and despite the fact that you can consider yourself, or not just consider, but probably you might be the better out there doing a due diligence, what you are auditing is information of the company. So if the company doesn't want to provide the information to you, there are some documents that even if you want, even if you go to public records, you will not be able to access them, because the reality is that, for example, a contract between the company and the security company, the company that provides security, it's a private agreement between the two parties. So if they don't disclose to you, you will never see it. In the same way, you can have a loan with a bank, or you can have any type of private agreement where there is a liability of 1 million, 2 million, 3 million, anything really. So that's why it's important to have some of these contractual tools to be protected from any of these potential liabilities. And just to conclude this, after closing, it's the post-closing phase. In the post-closing phase is, remember that the closing is that when you pay and the shares are transferred. So now you have a company, new ownership. In the post-closing phase, what you will do is mainly update corporate records, replace previous shareholders with new shareholders. You will replace the management, so you will appoint new directors. You will issue powers of attorney to those who are going to represent and act on behalf of the company. You most likely will do some press announcements to make sure that everybody is aware of what has just happened. And then you will do what I tend to call sometimes as a little bit of tidying up. That means, I don't know if you need to change the corporate name because you want to align it with your current vehicle, or you're going to keep on exploiting them with under different corporate names. Then will be issues such as, in many of these transactions, you contemplate the possibility of a merger between the company that you're acquiring and your current existing company. And then that merger can be a merger of equals resulting in a new entity, or it can be company A absorbing company B, or company B absorbing company A. So this gives you A plus B equals A plus B equals B, or A plus B equals C, any of the three possibilities. But all of this is something that will be done after the transaction has been completed. And then the lawyer will also prepare what is known as a transaction Bible, which is a compilation of all key documents of the transaction in their final form. And they will hand this to you, usually leather bound with gold or silver letters, whatever the preference of the firm is. And you will have the latest draft of all documents, because there will be need to make reference to them, particularly if there are some hidden liabilities, or there are some things that start popping up after the transaction is completed. Charlotte, we have a very quiet crowd. There have been no questions. There have been no much interaction.
We do have someone with their hand up. So I think Jayantha would like to ask a question. So Jayantha, I'll click the button to allow you to talk if you want to ask the question vocally to us. You'll just have to unmute your microphone.
Or you should just raise your hand to say hi.
But normally it means you want to ask a question. I have put the ask to unmute. So if you want to unmute, you're welcome to ask us a question. It seems very quiet. So perhaps either it's been clicked by accident or not sure how to unmute. So if you want to unmute, you're very welcome to. If not, feel free to ask a question in the chat.
And if you cannot unmute yourself, you can put the question on the chat.
Yeah, absolutely. Yeah, it does see everyone. You're obviously, I usually see that if you've got not got any questions, you obviously explained it very well, Rodrigo. As a compliment.
Charlotte, that's very kind of you. I usually prefer when there's a little bit of conversation.
Of course.
Next time I should try to be not very clear on purpose.
Sometimes it always takes a little bit of time. I guess what I would find useful is if obviously we're inviting people here that usually have offers to come and study with us at Queen Mary, in particular banking and finance LLM. So have you got any words of wisdom or any encouragement for the attendees as to if they're on the fence about coming to Queen Mary and why they should come and study this LLM?
Oof, I have lots of things to tell you, but realistically and as objective as I can be, I was a lawyer, and there's usually this kind of non-written requisite that you need to do a master's abroad to advance in your career. And I came to the UK to do my LLM, and 20 plus years later, I'm fully established in the UK. I'm a professor in one of the leading universities in the UK, and I would say probably in banking and finance, we are unrivaled in Europe, Asia, Africa, Latam. We have some competitors in the US, but basically on banking and finance, we are very, very strong because of the fact that we do both the regulatory and the transactional. And we have kind of this divide because students might prefer to do more transactional or they want to do more regulatory, but we provide both. In addition to that, we offer some kind of niche modules, like for example, if someone wants to study about financial derivatives, usually financial derivatives is a subset within a course on international finance. We not only provide international finance, we also provide corporate finance, and which is a big distinction, but also even within going to the example I was giving you about financial derivatives, we also have, for example, a specific course only on financial derivatives. And we complement that with one on risk management. So the beauty of Queen Mary is that it offers so many courses. Well, the beauty, but also that is the problem. We offer so many courses that you can really build your LLM in the way that you want. The challenge is that you will have so many options that it will be problematic to choose, but I think that that's a nice problem to have. The other thing is that academics at Queen Mary are at the forefront of development, and we are involved in policy, we are involved in transactions. For example, just to give you an idea, I was here in Paris yesterday. I organized a conference with people from the United Nations, from the African Development Bank, from the Paris Club, a partner from a law firm, the managing director of a financial advisor. Tomorrow, I'm catching the train in an hour and a half. Tomorrow, I'm in London. I teach 9 to 11, and as part of my class, I have someone from the World Bank who will come to talk to my students about non-performing loans. This is just to give you a flavor. I am involved at the moment. I am working on a project of law reform with the European Bank for Reconstruction and Development. I'm not sure I'm allowed to say the country, so I will have to spare you that. But also, equally, I got a paper that has just been accepted for a special edition of a journal of the United Nations. Or, for example, I am actively involved in restructuring the debts of an African country, which is live and going on as we speak. But this is not just me promoting myself or my CV. The same happens with my colleagues advising the House of Lords, advising the IMF, and this gives us a competitive edge because we are doing these things for real and we bring this into the lecture room.
Brilliant, thank you. That's really helpful, and I'm sure will help people's thoughts when they're thinking about what they're going to do next. We do have a very quiet audience, so
guys, at least as a favor, can you tell us whether you are able to hear us and that there are no questions? Please,
I will
or on the Q&A box if there are, at least that there are no questions, to make sure that you are listening to us and that we have not been talking to ourselves.
I will put the email address of the student support team in the chat. So if you've got any particular questions for them that you want to ask, then please do. Oh, someone said no questions. So you've obviously done a very good job, Rodrigo.
Okay.
Thank you, Sarah Jean, for that. That's really helpful. At least we know we're definitely coming through. I will put, yes, I'll put the email address in the chat. So if you do have any questions relating to your application or just about kind of starting in September, welcome week, induction, anything like that, please feel free to get in touch with them. And I suppose if there's no question, then I will close it and give Rodrigo some of his time back, because he's got a very busy day over in Paris. Lecturing at 9:30 this evening is very late slot.
9:30 till midnight.
Wow.
And then tomorrow I'm teaching at 9.
That just shows our dedicated academics that we're very lucky to have. Well, thank you, everyone. I'll put the email address in the chat now. If you have any other questions at all, please feel free to get in touch, and we'll do our best to get back to you. Oh, someone's put, it's great, and I've got in-depth knowledge, banking and finance law frames. So that's good. You've done a good job, Rodrigo. So thank you.
Okay, thank you very much. Thank you, everyone.
Thank you, everyone. Take care.
Thank you for joining, and hopefully I will see you in September this year.
Lovely.
In person.
Thank you, everyone. Cheers. Bye-bye.
Bye.